Cram-down is one of the most consequential and most misunderstood provisions of bankruptcy law for secured creditors. It allows a bankruptcy court to confirm a plan of reorganization over the objection of a class of creditors, including secured creditors, if specific statutory requirements are met. Here's what secured creditors need to understand about cram-down and how to fight it. What cram-down means for secured creditors. In Chapter 11, Chapter 12, and Chapter 13, a secured creditor's claim can be bifurcated into a secured portion, equal to the current value of the collateral, and an unsecured portion, the deficiency. The plan can cram down the secured creditor by modifying the loan terms, reducing the interest rate to a market rate, extending the loan term, or restructuring payments, but the plan must provide the creditor with at least the present value of the secured claim. In simpler terms, if you hold a $200,000 mortgage on collateral worth only $150,000, the bankruptcy plan can bifurcate the claim, treating $150,000 as secured and $50,000 as unsecured, and restructure the secured portion on new terms, as long as the present value of the payments you receive equals $150,000. The anti-modification protection in Chapter 13, Section 1322b(2) prohibits modification of a claim secured only by a security interest in real property that is the debtor's principal residence. This is a critical protection for residential mortgage creditors. You cannot be crammed down on a purchase money mortgage on the debtor's home in Chapter 13. This protection does not apply to mortgages on investment property, multi-unit property with more than 4 units, or commercial real estate. The Chapter 11 cram-down rule. In Chapter 11, cram-down over a class of secured creditors requires that the plan either give the secured creditor their collateral or allow them to retain their liens securing the full amount of the allowed secured claim, plus receive deferred cash payments whose present value equals the allowed secured claim, plus the plan is fair and equitable, a standard that prohibits any junior class from retaining value while senior classes receive less than full payment. How to resist cram-down. Challenge the valuation of the collateral. The cram-down amount depends entirely on what the collateral is worth, and collateral valuation is often contested. Challenge the interest rate proposed for the cram-down. Courts use market rate analysis to determine appropriate cram-down rates. Object to plan feasibility, show that the debtor doesn't have the income to make projected plan payments. People Locator skip tracing investigates debtor income and asset values in support of secured creditor positions in bankruptcy. Visit peoplelocatorskiptracing.com to place your order.